I am no stranger to this part of the world. I always believed that we were part of the same state. Some of my earliest cases written about in the book actually were in Springfield and in Greenfield, or I would have those clients come to litigating something in Boston. But I always loved this part of the world. I see former clients in the audience, and former students in the audience, which was really wonderful. It's really a pleasure to be here. The book, I'm in an odd kind of intersection of three identities. And if I seem a little confused, it's because of that. So this is a book about from the time that I was admitted to the bar, which was in 1972, to the time that I became a judge, which is in 1994. And then I've been a judge, and now I have a whole other career. And the thing is that I am allowed to talk about my experience being a lawyer. Of course, I'm not allowed to talk about my experience as a judge, or not much. So that's a book that'll come out September 2nd. But the book begins. The genesis of the book, which oftentimes happens, is that I was waiting to be confirmed by the Senate. Ted Kennedy had nominated me for the District of Massachusetts, and although I had gone to law school with Bill and Hillary, the fact of the matter is that it was Ted Kennedy who decided that this would be a good thing, and it was a remarkable thing for him to do. I was supposed to go through all my papers to see what would embarrass the president. So I went through everything. And I had boxes and boxes of things. I am a pack rat of major proportions. I had everything. I probably still have the class notes from that class. So we can compare notes. So I went through everything to see what would embarrass the president. And I decided that everything I had ever done in my life would embarrass the president. Of course, although this is not in the book, we also learned that Bill Clinton couldn't be embarrassed. But since I didn't expect to be confirmed at all, a friend of mine sat down with me and said, "These are great notes for a book. Why don't you write a book?" And I figured that would be my next stage. I'll be writing a book rather than being a judge. Well, wouldn't you know it, I was confirmed. And it took 6 years to write the book. And when it was finished, it's an interesting feminist story, actually. When it was finished, the publisher that I had submitted it to didn't like it. It was exactly the book that they had contracted for, but they didn't like it. They wanted me to write about my family. They didn't think that young women in particular would care about a story of work. They thought that young women only wanted to hear about how I combine my work with my family. That's an important thing to talk about, but that wasn't the book that I wrote. And the answer to how I combined work and family just walked in. It was, the mission was a joint mission. Both the work, which I did with him, and the family, which we did together, this was a joint mission, and that was why I was able to do it. So the book sat on the shelf, and only a year ago, I was giving a talk at a conference that was honoring Justice Ginsburg, and I was telling some of the stories that I had collected from the book. Someone from Beacon Press was in the audience, and that's all she wrote. And suddenly this book is coming out just at the time that I'm retiring from the bench, and all my lives are colliding. I want to read a little bit about it because I think it is a story. First, it's my story, which is a very odd and unique set of facts, a sort of improbable career. But it's also the story of women of my generation. And a story, it seems to me, that has to be told. All of us have to tell our stories because the next generation of women don't realize how recent this has been. The stories of, the demeaning stories in courtrooms, which I tell in this book, only happened a relatively short time ago. So the stories are terribly important. It's also the story of the 60s, the story of the 60s and the early 70s of lawyers who went into civil rights and criminal defense work as part of a civil rights approach. We were regularly representing unpopular people, and we were putting our skills at the service of people who desperately needed us. It was a whole other generation of lawyers. So it tells that story. And then at the bottom is a story which I love to tell law students in particular who are persuaded that there's not much they can do with their lives and who are enormously cautious, that it's possible to do what you think is right and actually be rewarded for it. And the first story I tell in the book begins in that tone. There was a panel at Yale Law School. There were two panelists, Judge Sonia Sotomayor and me. I had been a judge of the U.S. District Court in Massachusetts for only a few years. Sonia was on the Second Circuit Court of Appeals in New York City. We were both Yale Law graduates, I in the class of 1971, she in the class of 1979. Sonia went first, speaking deliberately. How does one become a judge? You graduate this fine institution with a stellar record. You work as a prosecutor in the celebrated Manhattan District Attorney's Office, and then as a corporate lawyer in New York. You have clear principles, and you take care not to be publicly associated with controversial causes. Rather, you speak your mind carefully, cautiously, but within existing institutions. You demonstrate in every way, in word and deed, that you can be a neutral, temperate jurist, and then you're nominated to be a judge. Her story was compelling. In fact, in little more than a decade, she'd be confirmed to the highest position that the American legal profession has to offer, the U.S. Supreme Court. And everything about her background, her hard-won and hard-fought career, but also her modest beginnings in the projects of the Bronx, would predict that she'd be a superb judge. It was my turn. I paused. How does one become a judge? I paused again. Yes, you graduate this fine institution with a stellar record, but then, and I paused for effect, ever the trial lawyer, my voice getting louder, the cadence quicker, you represent the first lesbian, feminist, radical, anti-Vietnam War activist accused of killing a police officer you can find. That would be your first major case in prime time. You take every abortion case in the Commonwealth of Massachusetts. You speak out on the major hot-button issues of the day in successive rallies on Boston Common or on television or in the editorial pages of the newspapers. You represent defendants of all stripes, from those in political corruption cases to high-profile murder cases. And in the final coup de grace, you marry the legal director of the American Civil Liberties Union. In short, after doing everything that in this political culture, in this epoch of strident judicial politics should disqualify you for the position, you become a judge. Sonia turned to me laughing. The students, no doubt stunned, then joined in. So the book tells the story of that journey. And in fact, although none of the reviews so far actually have caught this, I can see a judge growing from the lawyer's tales. I'm not sure that anyone else can, but I can see it. I'll tell you three stories. The first is the case that really kept me in practice. We find people in my court for that. Or embarrass them, either or embarrass them, right? Look at the color of his face now, my God. So there are three stories. As I said, the Sachs case, which I'll explain in a minute, was a case that sort of defined me. I had no intention of ever being a lawyer. I went to law school. I got a master's in political science. I planned to be a professor. And that was that. But I decided I would take a detour in practice to see how it was and then go back into the library. The Sachs case changed all of that, and I'll describe it in a minute. And Susan Sachs was the paradigm of the despised client. The second case I want to talk to you about is a case that no one had ever heard of, but the issue made people uncomfortable, and that was the story of a woman who sued her psychiatrist for sleeping with her. She was a woman who, after all, was seeking psychiatric help, and this was a high-status psychiatrist who denied everything and furthermore said, not surprisingly, she's crazy, I'm not. And the third case was a case that took place in Springfield. It was a case of representing a woman who had killed her husband and who was claiming battered women syndrome. and I tried it really just in Springfield. This was several years ago. So let me start off with the Sachs case. When I was 29 and she was 25, I represented Susan Sachs, an anti-war activist accused of robbery and murder. The judge persisted in calling me Susan Gertner. Even Susan's mother confused me with her daughter. The prosecutor assumed that since Susan was gay, I was gay. And that rumor persisted for 20 years. A husband and 3 children later, when I was nominated to be a federal judge, there it was. I identified with my clients deeply, and Susan even more than most. But I was the lawyer, not the client. Empathy was a given. Detachment was what I had to learn. So the Sachs case was this. In September of 1970, 5 people robbed the State Street Bank and Trust Company. 3 men were ex-cons who had been on the Brandeis campus for the purposes of doing a post-release program. And there they had met Susan Sachs and Kathy Power. Susan was 20, Kathy Power was 21. This was a time in the anti-war movement which people don't necessarily talk about. You talk about the demonstrations, you talk about the civil disobedience, throwing blood on files. But this was a point in the anti-war movement when things began to get violent. And Susan Sachs, the rationale for the robbery was to rob the bank in order to fund the anti-war effort. At this point, the newspapers were filled with stories of the townhouse in New York City that had blown up, and Kathy Boudin was seen running from that. Bernadine Dorn was the second person on the 10 most wanted list. Sachs was the first woman. Sorry, Bernadine Dorn was the second woman. Sachs was the first woman on the 10 most wanted list. While it sounds now, we look at the anti-war effort in a somewhat glossy way. By 1975, when Susan was caught, it was not so. The publicity against Susan was virulent. It was anti-feminist. It was anti-war, anti-war. It was anti-gay. It was clear that Susan was gay. And there were aromas of anti-Semitism. So into this I step. It never dawned on me that I might be asked to represent Susan. I'd been a member of the bar for only 2 years, since December of 1972. Although a partner in a small civil rights criminal law firm, I was a complete novice. I believed I was not long for trial practice. I wanted to be a law professor. Sonia Detman, a client and a friend, called to talk about Susan's capture. She had been captured in 1975, 5 years after the robbery. She was Stanley Bond's widow, one of the participants in the robbery. They had married while he was in prison on another charge after the State Street Bank robbery. Although she had never met Susan, she wanted to help in whatever way she could. Susan would need representation. Would I do it? Of course, I said without hesitation. Writing this now, I try to understand how I had the nerve to say that. To some degree, one explanation for that was that Susan and I were not so far apart. Our paths had crossed on the New Haven Common in May of 1970. Both of us were there, the future lawyer and the client-to-be. I was a legal observer. It's the span of 4 years between us. I was a legal observer. She was a participant. Yale Law School had always been progressive, but those years won the prize. I had taken Spanish for law school credit, thinking I might represent migrant workers in California. By the spring of 1970, when the law school shut down and there were strikes all around the country, all I knew how to say was, "La policía atacó les estudiantes." The police attacked the students. I couldn't find the bathroom if my life depended on it. And whatever traditional curriculum there was at Yale, I missed. When I took the Massachusetts bar exam, and this is true, I thought dying intestate was a disease related to prostate or something like that. So that's the person that she confronted. Susan was apprehended when walking down a Philadelphia street. There were charges that were in Philadelphia and then charges in Massachusetts. The charges in Philadelphia were for another bank robbery. She was caught in Philadelphia. I was just doing backup work in the case, pretending that I knew what I was doing when I didn't. But when the federal charges were resolved, the case moved to Massachusetts, and Katie Rohrbach, a very celebrated criminal defense lawyer, decided she did not want to take on the Massachusetts murder case. She didn't want another long trial away from her New Haven home. She had already experienced her Susan Sachs case when she had represented Black Panther Erica Huggins, a woman about whom she had cared deeply. She recommended me to Susan, and more important, urged me to take the case. It's not often, she said, that your work and your heart come together. Don't let this chance pass you by. However much I had disagreed with what Susan was charged with doing, whatever different choices I had obviously made, she had acted out of conscience and now faced the rest of her life in prison. I could not turn down a chance to make a difference to her, someone my age, my generation, even my background. I describe how similar our backgrounds were, and someone whom over time I grew to love. Teaching, my intended direction, could never measure up. Moreover, I just could not admit how frightened and overwhelmed I felt at the prospect of representing her. Because the inevitable they, my father, my professors, my legal colleagues, society, thought that women were not tough enough for criminal defense work, I had to prove that they were wrong. Susan had taken far greater risks than I ever had, greater than I had ever imagined. The Vietnam War was over. Whatever passions had moved her and others in 1970, even to many of those who had once been in the anti-war movement, seemed a distant memory. Her acts were bound to be viewed through a different and far more critical lens. So Susan asked me to represent her. She figured she was going to go away for the rest of her life. What's the point? She might as well have the representation of her reflect her values. So there was going to be an all-woman team, me at the helm, all women doing jury selection, a woman investigator team, which was just hysterical, but that's another story. And that would represent her, and to her, it didn't matter whether I won or lost. Of course, I had a different agenda. Did I worry that little or no money was involved? No, but my partners did. The case, likely a loser, could take down our new practice, then Silverglade, Shapiro, and Gertner. But after a small contribution from Susan's parents, my partners agreed. Harvey would keep the law afloat, the firm afloat. This is Harvey Silverglade. Tom, perhaps 3 years more experience than I had, would keep his practice, but he'd also work with me on the case. Did I think about the family of the slain officer and the enormous toll that his death had taken on them? I think about it now, a great deal now, but I didn't then. I thought I wasn't supposed to. I thought advocacy had to mean putting on blinders and focusing only on my client. Candidly, that approach was functional. It was too hard for a young lawyer to separate the personal from the professional, a human being's empathy from an advocate's single-minded focus. Did I think about the political implications? Not much. I had a well-worked-out of abstract theory about political trials. This had been part of the law of mass arrest curriculum at Yale. But I also knew that the violence of the early 1970s had threatened to undo whatever popular support there had been for the anti-war movement. To do what I had to do, and now what I wanted to do, I had to be monomaniacal. I wanted to save this young woman's life and somehow believed I could. So when Susan asked me how many jury trials I had done, I rounded them off to the nearest 10. When she asked me how many years I had practiced, I rounded off the 3 years to the nearest 10. She knew better. It was the last time I wasn't totally honest with her. I describe in the book not only the odds of representing this unpopular woman, but also coming out of nowhere, being a young woman, 29 years old, that no one had ever heard of. Officer Schroeder was lionized. He was the very best of the force. He's the officer who died. Decorated for bravery, a religious Catholic, 9 young children, each of whom would follow in his footsteps into public service. The judge was a bright, no-nonsense judge who carefully controlled the courtroom. He had presided over the prosecutions of the 3 other men. He didn't think this was going to be a problem. This was going to be easy. The prosecutor was reputedly one of the best in Suffolk County, having lost only one of the 200 murder cases he had prosecuted since joining the DA's staff. He too was a religious Catholic, as well as a wounded World War II veteran with a Purple Heart and a Bronze Star. And me, I was invisible. The day the trial began, after 2 years of high-profile pretrial hearings in which I did all of the arguments, the headline read, "Sachs trial opens today. Prosecutor able, tough." Me, I was a potted plant. If they mentioned me at all, I was, quote, lady lawyer, end quote. Remember those days? Or, quote, Ms. Gertner, she prefers that designation. Butting heads with Gaffney was like dealing with the catcher trash-talking the batter at the plate. When I wore a loose-fitting dress, he cracked I had no business looking pregnant when I was representing that lesbian. At a hearing to determine the admissibility of a survey of the attitudes of potential jurors, he asked only one question of the woman PhD who headed the survey team. Were any of the survivors gay? Were any of the surveyors gay? To the press, he bragged he'd spent only a fraction of the time that I was pouring into the case. He'd been through it all before with the three men, and asked if he had ever tried a case against Nancy Gertner and Tom Shapiro, the defense team. He replied, "Oh, have they ever tried a case before?" "Yes, but only a few. You have to start somewhere." I won't go into the details. It's a compelling story, I think, because it's a story of two outsiders, one who was on trial and one who was representing her. The case took 2 years to try, which was very helpful because I literally didn't know where to stand in the courtroom. There'd be times that issues would come up and I would turn to my partner and say, "What are they talking about?" Luckily, by the time the trial happened, I knew more what I was doing. And one of the advantages of being a woman lawyer with no experience is that I looked up everything. I went to social workers and sociologists and psychologists. I talked about social psychology in the courtroom. I was a blank slate, and I was not about to admit to any of my male colleagues that I didn't know what I was talking about. And so the case went on. To make a long story short, the case was tried in September of 1976. And the evidence against Susan began to come in much weaker than anyone ever anticipated. In fact, ironically, people only remembered the men. No one could identify her because they were focused on the men. There were no eyewitness identifications at all, and indeed the one teller who thought he really could identify the person, identified me. Yes, that's right, identified me. It took a little trial lawyer manipulation to get him to identify me. He described the woman in the bank, a certain height and a certain weight, and actually Susan and I were physically very similar, and so I went up to him using really by now, to some degree, the fact that I was a woman, and I could say to him, "Would you say that she's about my height?" "Yes," he says, and then I would say, smiling broadly, and I hate to admit this, about my weight. At this point, the witness was giggling on the stand and said, "Yes, about your weight." So your description could fit me? Yes, it could. So the case went on like this, much weaker than anyone ever anticipated. But still, as the government's case wound to a close, it was clear we had no defense. We had no defense. And so what we did is we allowed the press and the government to believe, because of course they would believe anything of me, that the defense was going to be a defense again about the anti-war movement. That we were going to have every icon of the anti-war movement get on the stand and say that it was right to do what Susan was accused of doing. She was right to do what she was accused of doing for the purpose of the anti-war movement. Now, of course, there was no way in God's earth that we were ever going to do that. But because I was a blank slate, they fully believed that I would do it. It would have been nuts. There was no question that it was a crazy thing to do. So as the government's case wound down, people were coming into Boston, the newspapers were interviewing them,
And the prosecutor decided that that he would rest his case without introducing two letters. He would hold them in reserve after this show of a defense and then wave them to the jury. What were the two letters? The two letters were letters that Susan had written to her father and her rabbi, essentially confessing what she had done. They were devastating. There was no defense to them. There was no explanation. So as the case wore down, we wondered what was going to happen with these letters. And finally, when the government said we have witness X or Y, and we knew that the letters would not come in through those witnesses, the night before the government rested, I practiced my third or fourth closing argument. And I went through it. The next day, by 10 o'clock in the morning, John Gaffney turned around to us and said, "The government rests." At that point, I'm told in a voice that sounded like Minnie Mouse, which is the way I sounded when I got nervous, I said, "Well, in that case, the defense rests." And it was a Perry Mason moment. Everyone rushed out of the courtroom, to call people up. But it was also an incredibly frightening moment because it was clear that if it had not worked, everyone's predictions of my fitness for criminal practice would have come true. So we closed the case. I did a closing argument. Government did a closing argument. And then we waited. Over a week passed. Each day I went to the basement of the Suffolk County Courthouse. She was guarded by state officials and a woman federal marshal because she was in the custody of both state and federal. I came to court in my lawyer costume, but in Susan's cell, I would change into a Minnie Mouse t-shirt and jeans. Once while we were waiting, I snuck in Chinese food in my briefcase. We had nothing to do except to be with one another and watch Bonanza reruns. I could be nowhere else, not in the courthouse, with the other lawyers, not in my office at all. There was one rumor that the jury was 9-3 for acquittal. By the next day, it was 10-2. Still another reported 11-1. The foreperson was quoted later as saying the jury tended towards acquittal. Many wanted to acquit to forgive and forget the passions of the anti-war movements of years past. Walking across City Hall Plaza after those rumors surfaced, Tom and I were exultant. It was a feeling like I have never felt in my life and ultimately could not stop wanting to feel. We might actually win. Then the jury announced that they were unable to reach a verdict. The judge declared a mistrial. It was clear that the government was embarrassed and offered a plea to which we could not refuse. The plea essentially meant that Susan got no additional time for the case in Boston and would go back to Philadelphia and serve the sentence that she had there. Communicating with a jury was a special feeling I had not anticipated, a kind of populism I relished, and a skill I had no idea I had. If I could communicate with my father, who was hardly political, the crowd from the Lower East Side, my family, Judge McLaughlin, or this jury, I believed I could reach anyone. And as for Susan, we've been dear, dear friends from then on. You saved my life, she said. In the final analysis, nothing else mattered. I described many other cases in between, but the next case I want to briefly describe, and very briefly, is a case involving the woman who sued her psychiatrist for sleeping with her. I was doing civil and criminal cases because I just was so excited. I can't describe it any other way. I just loved the work. And if someone came in with an interesting case that I knew nothing about, I accepted it. Because after all, I knew nothing about anything. So it was easy to accept a case. So Barbara walks in, and she said, I just want to read the beginning of this. In 1977, the firm couldn't afford walls that went all the way up to the ceiling. Partitions covered 3/4 of the space with an open area at the top. There was one all-purpose, windowless, middle-of-the-office room that was a library, conference room, and lunchroom. We were generally a fairly rowdy bunch of about 15, sharing the work, the strategy, and the losses. When I scheduled Dr. X's deposition in this less-than-private setting, I took special precautions. I asked my colleagues to take coffee breaks only at their desk, no shouting across the room, that was our intercom system, No loud strategy sessions or running commentary. I assured them that I would give them the signal when I was about to ask the question. And when I did, everyone lined up outside. Dr. X, I asked, slowly enunciating my words the way you do when you are really self-conscious. Yes, I couldn't say on the radio. Do you have a small nodule on the left side of your penis and a red mark like a birthmark on your left buttock? He paused. He looked at me, eyes wide, then narrowed in contempt, and he ran for the door. Let the record reflect, I said, pretending to be calm, that the good doctor had just bolted. My client was suing her psychiatrist for malpractice. She claimed that he had had sex with her during their psychiatric sessions nearly every week. Her current psychiatrist referred her to me in the middle of the Sachs trial, not because of my extraordinary experience at malpractice cases. Again, I had none. It was gender that made me seem appropriate, the assumption that as a woman I would believe her, that and my new reputation for fighting against all the odds. I did believe her. True, at this stage I believed everyone. There was a man who came to consult with me about a counterfeiting charge. I was so flattered. After an hour of advice, he thanked me and asked how much he owed, and I said $50. Yes, he gave me a $50 bill. Undoubtedly counterfeit, I was too embarrassed to put it to the test. So I believed Marcia because her story was conceivable to me, and not many women in the room would probably recognize this. I could imagine it happening. I'd been treated by a dentist who insisted on using laughing gas, and as I went under, started to touch my breasts. I had heard similar stories from other women about trusted professionals. The fact that no one before had sued a psychiatrist was no impediment. Did it matter that Dr. X had a major insurance company and 2 fancy law firms behind him when I had only my 2 partners who knew even less about malpractice than I did, and an office without floor-to-ceiling walls? So I go on to describe the activities. One of the reasons why I had asked her to tell me what the doctor looked like was because as a criminal lawyer, I didn't like the odds. I didn't like the he said, she said. Because ultimately she was, after all, someone seeking psychiatric help, and he was a high-status professional. And again, not knowing about malpractice to some degree was another blessing. I read everything, and I was capable of reinventing the wheel. I don't recall, as I said, whether I asked the question or whether or not she did, whether she raised this, but then she reported Dr. X's private parts. After the deposition, I filed a motion to compel his response. After more delay, he agreed to resume the deposition, although he wanted it to be at his office because of the noise problems at mine. I refused. He came to the deposition, denied having such marks, and left again. This was the problem. What do you do next? I filed a motion for a physical examination in the civil motion session of Suffolk County, the same court where I had tried Sachs. In the firm, we called this the motion to take a view. We speculated how the trial might proceed. At a critical moment, would I direct the defendant to turn and moon the jury? The judge, the Suffolk Superior Court, again, I'm the only woman in the courtroom, just literally the only woman in the courtroom. The judge is an older male judge. He reads the papers, which had, penis and buttocks in them, looked at me, turned crimson, and like the doctor, bolted. Days later, we learned that he had allowed the motion. He was too embarrassed to say it out loud. To make a longer story short, finally the examination was scheduled. I had retained a very fancy, this time a plastic surgeon, because I had no confidence that the doctor had not done something to himself. Dr. Constable told me that one mark could be removed without a trace, and the other one could not. I was at the Mass General Hospital. Inconspicuously, I thought, I was the one in the red suit pacing back and forth. The case had come down to Dr. X's private parts. The insurance company was going to walk away if the marks were confirmed. If he had done the deed, they reasoned it was not just malpractice, but his private pleasure. And to my client, the stakes were even higher. She thought that if there was no evidence of marks on the doctor's body, I would dump her. She continued to confuse my professional judgment and my personal support. She conflated the statement, "This will weaken the case," with, "I don't believe you." At 7 p.m., Dr. Constable met me in the lobby. We shook hands, but I was completely incapable of small talk. And then he said, "There's good news and bad news." The bad news was that in the place he said the mark could be removed, if anyone wants to know, on the doctor's penis, there was no sign. But on the buttocks, there was a mark. There was a scar. Someone had obviously tried to remove that which they could not remove. Trial was scheduled very shortly thereafter. The Friday before the Saturday of trial, I suddenly get records. The records were from an emergency room in Maine, and the records say that Dr. X had fallen off a stone wall and landed on a broken bottle. And that was the explanation for the scar. I feel like there's a wonderful character on Saturday Night Live who looks in the audience and goes, "How convenient." Now, I could have raised holy hell about the timing of the records. This is on the eve of trial, but, I was never that kind of a lawyer. The procedural, technical stuff was less important to me than getting to the bottom of this. So I sent out my investigator, the same investigative staff from the Sachs case, Berna Aronson, who was Susan Sachs's lover. Berna was very imposing, slightly overweight, into wearing leather and chains. She was the perfect investigator as far as I could see. I told her to interview the emergency room doctor. Perhaps he was a buddy of Dr. X, and contrive the records. Go to the site of the fall, take measurements, get pictures, look for witnesses, find out about the weather, learn anything about the accident. Berna called me late on Saturday evening. I'm a workaholic. She knew I'd be up and indeed crazed. She said, the temperature on the date of the fall was well below freezing in Maine. There were 14 or more inches of snow on the ground. Unless the doctor was walking around nude or in shorts rather than in layers and layers of winter clothes, it was physically impossible for him to have fallen off a stone wall and cut himself in the fashion he described. That Monday, the case settled. But the story isn't over. The condition of settling the case was that the woman I was representing had to keep all this confidential. Hence, in the book, I talk about Dr. X. Had to keep all this confidential. And she had to, in fact, withdraw all her claims against the doctor in the Board of Registration in Medicine. In the summer of 1997, many years later, I was having my hair done. The hairdresser, making conversation, reported he had just been a juror in the state case. The case was against a doctor for malpractice. The claim was that he had had sex with a woman patient. The hairdresser said that while the jury felt for the woman, they simply could not believe her rather than him because no other woman had complained. The doctor was exonerated. What was the doctor's name, I asked. It was Dr. X. But the story gets even better. A few years ago, when the Boston Globe reported on the sex scandal in the Catholic Church, the church came forward showing that they had done everything they could to take care of these individuals. Everything, all the priests accused, they would have to go into counseling. And they described in the article who the counselor was. And yes, the person they had sent them to was Dr. X. Fast forward, the case goes on to cases that I took really after I had a family, when I would do closing arguments with baby vomit on my shoulder. That was you'd be in the middle of doing closing argument, look over, you go, oh my God. Whose is that? And then it leads to the final two cases, which I will only describe very generally, which is one was the case of Lisa Becker Grimshaw, who was tried in Springfield for killing her husband. The case had gone on for many years, and she kept on calling me to represent her. And at that point, I was having one baby after another and couldn't represent her. She said she'd wait. I finally get to represent her. It is the most difficult battered woman case imaginable because while she had been beaten by her husband, and it was clear that she'd been beaten by her husband, it was also clear that the murder had taken place at some time later. In other words, it was not a spur of the moment. And the killers was a man that she was dating at the time. They had separated, and this was a man that she was having a relationship. So it was almost as if there were two narratives here. The government's narrative, which I describe, was cold-blooded first-degree murder. But then there was her narrative, which was unimaginable beatings over the course of several years, and a night when these men came to her house, one of whom she was dating, and she said what the latest beating had been, and they said, "We can't stand it anymore, let's go find him." This is the story, really, of the closing argument. I won't read it all. It starts, "Peter, my 14-month-old, was up all night before the closing. The trial of a woman accused of murdering her husband was 2 hours away in Springfield. I spent every other night there to minimize the time away from the boys. There was a newborn and a 2-year-old. With no sleep except for a few minutes in the car, I was going on pure adrenaline. I paced back and forth in the silent courtroom, telling Lisa Grimshaw's story, a story so far from my own. She was the youngest of 3 sisters. The older 2 had been raised in comfort, but by the time Lisa was 10, her father was unemployed. Often drunk, he would fly into unpredictable rages. At first, the target was his wife, but soon it was Lisa. Alone with her father after school, the abuse turned sexual. At 14, she fled to Darryl Fredette. He was a batterer too. Her face was his favorite target. I was the one who knocked out her front teeth, he crowed at the trial. A son was born so badly retarded that within months he was in foster care. Then from Darryl to Tom Grimshaw, who was the victim. And again, a story of battering. 5 months before Tom's death, in the middle of the night, Lisa awoke to the sound of breaking glass. Tom smashed the glasses open. Then he knocked out her front teeth with a hammer. The second time, her teeth were bashed out at the hands of an abusive lover. This is from the closing. This is the narrative. I pause. I bring the chair directly in front of the jury. I sit down, lean over as far as I can, and wrap my arms around my legs. This was as close to a fetal position as I could get, dressed as I was in court clothes and heels. For the closing, I would relive Lisa's story of the hours before Tom's death. I would transform myself into her. And I did. The jury was out for several days. The jury came back with a manslaughter verdict, which I regarded as a victory since she was facing first-degree murder. We did an elaborate presentation at sentencing for the judge. Surely the judge would take into account what the motivation was for the murder. She'd been convicted. Time was in her future. Incarceration was in her future. But surely he'd take into account what her past was. The judge, whom I don't name, sentenced her to the maximum, 20 years. Thereafter, Lisa joined the numbers of women at Framingham who were in there largely for having killed their batterers. The story ends reasonably well. After a period of time in jail, there were numbers of women who were pardoned, actually, because they had been unable to raise battered women syndrome. Lisa's sentence was commuted, and she was released based on this record. So, the stories go on. I was touted for this case. People thought it was fabulous. Within a year, I was picketed. And the next story is the story of, which I won't read to you, was the story of representing a man who was accused of rape. It was the only time I did a rape case. I did not, in fact, turn down rape cases. Not because I didn't think people needed to be represented, but because after the Sachs case, it was clear that I was getting these calls not because I was the best lawyer in the galaxy, but because I was a woman. And I felt like my personhood was being used, and I didn't want to do that. The case, so there was that, being picketed on that. Then I describe how I sued every university in the United States almost for sex discrimination of one kind or another. Indeed, I even sued the court I'm now a part of for sex discrimination. That's a fun story. And finally, I end with Matthew Stewart. The question that I ask all the time, which is not the subject of this forum, but which I really want to answer sometime, is isn't it a fact that an activist lawyer is going to be an activist judge? And the question is asked pejoratively. Well, I tried to think about the seeds of judging in this book. And what they are is this. First, I learned to love the notion that in the United States we can go into court, haul anyone into court. People who are powerless can sue the powerful. That's what we did. People can stand up to the government that accused them of crime. Women can sue Harvard University or other institutions. And what a remarkable it is that we have that place. I also recognized more powerfully as my career went on how hard it is to make the system fair. The system relies on the passion and the work of its participants. It is not automatic. In fact, during the Sachs case, which is billed as a great victory, I learned later on that the judge in the Sachs case was meeting with the prosecutor every day to try to figure out what I was doing. So the notion of how hard it is to make the system fair, those two concepts, loving the notion that this is a place for us to assert our rights, and how hard it is to make the system fair, in fact, animates my judicial career. But I won't go into too much detail about that because that's the next book. Thank you very much.